Please, Lordship.
Yes, please.
Lordship, I beg to mention hearing item 23 and 24. The analogous matter, Your Lordship. I have personal difficulties today, Your Lordship. If this matter will be taken up on Monday, I have taken the consent, Your Lordship.
23
and 24.
I'll make it on Tuesday. 23 and 24.
Lordship.
You're the counsel for the
I
petitioner
am for a petitioner.
on the prayer of Mr. T.P. Jamil, learned counsel for the petitioner.
Tuesday will be 10.
Listed on 10/9/2024. Okay.
Obliged.
Obliged, Lord.
May I please, Your Lordship?
Yes, please.
My lord, I beg to mention item number 19, hearing item. I pray for 3 weeks time,
Item 19.
19.
Yes. On the prayer of Mr. M. Timson, the learned additional AG. Listed after 3 weeks.
Your
Okay.
Lordship, there is an interim.
Stop the interim order passed earlier, shall continue till the next return of the. Okay.
Much obliged.
May I please, Your Lordship?
Yes,
I beg to mention hearing item 22 on behalf of Peace Rain.
huh. Yes, what is your prayer?
The matter may be listed up to 3 weeks. Lord.
Mr. So-and-so. Learned counsel makes a mention on behalf of Mr. P. Surel, learned counsel for the petitioner, and seeks adjournment of the case for 3 weeks. Prayer is allowed, listed accordingly. Okay.
Reply.
May I please, Your Lordship?
Yes,
I beg to mention item number 14.
40.
14. Lordship, with the prior permission from the other side, may this matter be adjourned for 1 week, as my senior is out of station.
Who is your senior?
Takakichu.
Mr. So-and-so. Learned Counsel makes a mention on behalf of Mr. Takakichu. Learned Counsel for the petitioner and seeks adjournment of the case for a week. Prayer is allowed, listed accordingly. Okay.
Obliged. May I please, my lord?
Yes, Mr. Nangan.
Lordship, I beg to mention item number 17. Lordship, I have taken the consent from the other side.
Huh.
If this matter can be listed after a week, next Thursday, my lord.
Okay. On the prayer of 17, correct? 17,
19, my lord.
item 17.
Item 17, my lord.
On
Yes.
the prayer of Mr. N. Angami, the learned senior government advocate, listed after a week. Okay.
Deeply obliged, my lord.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 6 on behalf of my colleague, AIME, Your Lordship.
Item,
6, Your Lordship. She's in
as
disposal.
per the list, let us see, as per the list.
This is a hearing list, Your Lordship.
Item 6.
Yes, Your Lordship.
Oh.
Your
Okay.
Lordship, after a week, Your Lordship, since she's indisposed, Your Lordship.
MS Inauli. Learned Counsel submits that MS AIME, the learned government advocate for the state respondent is indisposed and therefore seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
Your Lordship, I also beg to mention item 15 on her behalf, 15,
Same order, 15,
after 2 weeks. This
after
one.
2 weeks, okay.
And even item 25 as well, Your Lordship, after 2 weeks.
Same order, after 2 weeks, okay.
Your Lordship, I also beg to mention item 13 on behalf of VG Momi, Your Lordship.
Ah,
This matter may kindly be listed after 2 weeks, Your Lordship.
same order, only on behalf of Vijay
Much obliged, Your
after 2
Lordship.
weeks, okay.
May I please, my lord? Lordship, I beg to mention item number 26 on behalf of my colleague S. Murray. Lordship, if this matter can be listed after a week, my lord.
Yes, Mr. N. Angami. Learned advocate. Makes a mention on behalf of MSS Mary, the learned government advocate, and seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
I'm deeply obliged, my lord. May I please, lordship?
Yes,
Lordship, my apologies, lordship, but in item number 15, there is an interim, lordship.
okay, item 15, the interim order passed earlier shall continue till the next returnable date.
Much obliged, lordship.
May it please, Lordship.
Yes,
Lordship, I beg to mention item 2, Lordship.
item
Item number 2, Lordship.
2,
Lordship.
let it come as per the list.
His Lordship.
Yes,
Lordship, I beg to mention for item number 20 and 21 on behalf of my senior IMT Mongchair. Lordship, kindly pass over for the day.
20 and 21,
Yes, Lordship.
MS Renzo makes a mention on behalf of Mr. Imti Longcha, the learned counsel for the petitioner, and seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
Would you like?
Obliged, Lord.
May I please, Your Lordship?
Yes.
I beg to mention item 26 on behalf of the counsel for the petitioner. Up to last-
26,
26.
26 has been mentioned. Mentioned? Just mentioned.
May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention item 18. Consent has been taken from the petitioner. Pray for 3 weeks, to be adjourned for 3 weeks, Your Lordship.
Mr. So-and-so, learned government advocate seeks adjournment of the case for 3 weeks. Prayer is allowed, listed accordingly. Okay.
Obliged, Your Lordship.
For motion from the supplementary course list, item number 27.
May I please, Your Lordship?
Hmm.
Your Lordship, here in this writ petition, the petitioner is challenging the appointment order of respondent number 4 to the post of medical attendant at Jiangsu Sub-Center under the establishment of CMO Woka. The present petitioner is a granddaughter of one of the landowner, that is late Shui and Remo Kitan, who had freely donated a plot of land where the sub-center at Jiangsu village Woka is
We
being
heard
constructed.
Mr. So-and-so. Learned counsel for the petitioner. The present writ petition has been filed. To question set aside the order dated. Where is the impugn order? 14/8/2024. Where is the impugn order?
Your Lordship, it's at Annexure J, page number 30. Annexure J, page 30. Lordship.
Order dated 14/8/2024. Issued by the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, appointing the respondent number 4 to the post of medical attendant at Jiangsu Sub-Center under the establishment of CMO Woka. Stop. No stop, no stop. And for appointment of the petitioner on the basis of land ownership. Issue notice to the respondent returnable after 4 weeks.
Oblige, Your Lordship.
Here's who is appearing.
Yes, for the state, Your Lordship.
Mr. So-and-so. Learned Government Advocate appears for the state. Therefore, no formal notice need be issued to the state respondents. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate when?
By 1 week, Your Lordship.
Within a period of 7 days from today. Okay.
Oblige, Your Lordship. Oblige.
For admission, item number 1.
Please, Your Lordship.
Yes.
Your Lordship, I have been informed this morning that the counsel for the petition is stuck in Dimapur, so kindly list this matter.
Stuck in Dimapur?
Yes, Your
He is in Dimapur, so he'll be stuck there. What is so big about that? Okay. Yes, what is your prayer?
I have an instruction to seek a 1 week time to list the matter.
Mr. Senso, learned counsel makes a mention on behalf of Mr. Tushitamjan Pangunar.
S. Temchin.
S. Temchin.
Yes.
The learned counsel for the petitioner and seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
For admission, item number 2.
Please, Lordship.
Yes.
Lordship, kindly grant me 2 weeks' time to file affidavit in opposition in respect of respondent number 4 and 5, Lordship. The affidavit is ready, but however, I'm yet to obtain the signature of
Respondent
the
number
respondent,
4 and 5.
Lordship.
What about the other respondents? What about state? State is a party. State is filed.
Yes, Lordship, we have filed.
What about the other respondents?
Your Lordship, I'm appearing for respondent number 9.
You have filed your affidavit?
Yes, Your Lordship.
Yes. You're for a respondent number?
4 and 5, Lordship.
4 and 5. Okay.
Lordship, here I'm appearing for 6, 7, and 8.
Have you filed your affidavit?
Yes, Lord.
Okay. 6, 7, and 8. What about 9?
Your
9?
Lordship. Your Lordship,
So you have filed your affidavit?
yes, Your Lordship.
Yes, your good name?
Lordship, W. Marco, Lordship.
Mr. So-and-so? Learned counsel for the respondent number 4 and 5. 6, adjournment of the case for 2 weeks to file affidavit in opposition. Prayer is allowed, listed accordingly. Any interim order there?
No, Lordship.
Okay.
My job, Lord.
For admission, item numbers 3 and 4.
Lordship, we have received the affidavit filed by the state yesterday, so 2 weeks time may be given, Lordship.
To file reply.
Yes, Lordship.
Okay. Ma'am, what is this IA?
Lordship, this IA, this NHIPCL states that the petitioner has been obstructing the construction. So the client has denied that, so we'll be filing our objection to that as well.
Okay, okay. So you want to file your reply to the affidavit in opposition filed by the state respondents? Filed by the state
Yes.
respondents.
Yes.
MS, your good name?
Wickets or no?
Vikat Sonyo, the learned counsel for the petitioner, submits that 2 weeks' time may be granted to her to file reply affidavit to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed accordingly.
Lordship, and the petition number 11, he wants to withdraw his name from the petition, Lordship. So if I may be allowed to take the necessary steps.
Yes, nobody is stopping you. You can file an application to that. effect.
Which number? 50.
You file an application to,
Yes, Lordship.
yes.
For admission, item number 5.
May I please, Lordship?
Yes.
Lordship, in this case, I am appealing for respond number 2, 3, and 4. I have filed my affidavit in opposition yesterday, whether it is on record. And I've been served copy of the reply to my affidavit in opposition this morning by the petitioner, your Lordship. So if those affidavit be called for, if it is not on record, and the matter will be taken up after the listed matter is over, your Lordship?
No, this
You-
is,
Now.
we listed for hearing in the usual
No,
course.
no, your Lordship, today the matter is listed for hearing on this thing, interim.
Interim.
Interim. So,
What is the interim?
yes, your Lordship, now, I wonder, even on the last occasion when the matter was moved, your Lordship, the petitioner has prayed for interim.
Interim is in your favor or in
No,
favor of the
no.
petitioner?
So, this honorable court did not consider the interim, but on the prayer of the petitioner, again, the matter is fixed today for interim, your
Well,
Lordship.
what is your prayer
So, my
for
prayer.
interim? What is your prayer? What is the nature of the case and what is your prayer for interim?
Lordship, the case pertains to transfer and posting of the petitioner
Uh,
to the post of OSD, Lordship. Now, I was serving as, I'm still serving as director, Lordship, higher education. While serving as director, higher education, I was placed as OSD, Lordship. And Lordship, I kindly appreciate, Lordship, OSD is not an cutter post, Lordship. It is an ex-cutter post. The rules, there is a rules, Lordship, set of rules for the department, 2015. The rules does not say about placing any of these members of the department to place as OSD, Lordship. There is clear violation of the statutory rules, Lordship.
You are serving as?
Director, Lordship.
You're serving as director of what?
Higher education, Lordship.
And what is your case?
My case is that, Lordship, the private respondent number 5 here, Lordship. I was placed as OSD and the private respondent number 5, who was serving as NCS joint secretary, Lordship, to the department, was placed as ex officio director, Lordship, by the same order on the same day, 27th of August, Lordship. Now,
So you still want to occupy the post of director?
yes, Lordship.
Okay.
On the next returnable date, the matter will be disposed on merit, your Lordship.
When did you file your affidavit, Mr. TV?
Yesterday, your Lordship.
And Lordship, I have filed.
Yesterday is 4th?
Yes, Lordship.
Yes, Lordship, 4th.
Okay.
Lordship, I filed my reply only this morning, Lordship, since I received only yesterday, Lordship.
Where's your reply?
Reply I have filed only this morning, Lordship.
Yes.
Records may be called for, Lordship.
The affidavit in reply filed by the petitioner to the affidavit in opposition.
Filed by
Filed
respondent
by
number
the
2, 3, and 4.
Respondent number 2, 3, and 4 is not on record. Registry to place the same and place it on record, listed on Tuesday. Next Tuesday, okay.
And your Lordship, in the meantime, status quo as on date be maintained, because that is our last order. your
Whether
Lordship.
that order is there?
Yes, status quo, your Lordship.
What is that order?
The status quo as
31st August.
31/8, your Lordship,
31/8.
Lordship.
31/8.
Parties have been directed
Yes,
to maintain
the
status.
status quo order directed by this code on 31/8/2024 shall be maintained till the next returnable date.
Lordship.
For admission from the supplementary post list, item number 28.
Yes, what is this?
Lordship, in view of the order dated 3/8/2024, passed in writ appeal number 28 of 2023. This matter has virtually become infructuous, so let it be closed, Lordship. And respondents were directed in the writ appeal to fill up the post of Secretary, Nagaland Legislative Assembly at the earliest, Lordship. Virtually become infructuous, Lord. This is with regard to the current charge in the post of Secretary, Lordship.
Okay.
Yes, we are giving a copy of the writ appeal, Lordship, which was disposed.
This is there on record. Mr. C.T. Jami, the Learned Senior Counsel, submits that in view of the order dated 3/9/2024 passed by the Honorable Division Bench in WA 28/2022, the present writ petition has become infructuous. They therefore submits that he may be allowed to withdraw the writ petition. The writ petition is accordingly closed as withdrawn. Okay.
Okay. For admission, item number 29.
What about this?
May I please, Your Lordship? Your Lordship, by the last order, I have been directed to obtain the instruction regarding this, regarding the payment. So, Your Lordship, here, this amount, this has been provision in the current year, financial year.
This has been provided?
Yeah, provision in the.
Where the civils?
My lord, as per the order dated 9/5/2024 of this honorable court, this court has given a specific direction to come with this direction as to instruction as to when the state respondents can settle the outstanding liabilities.
Where is your instruction? Where is your affidavit, Mr. MT?
No, not yet. I have not received, but as per the information that this amount has been already provisioned in the current financial year.
How information will work in this court? At least if you have information, you are an additional AG, you can direct the department.
Yes.
Furnish me in writing.
Yes, I'm waiting for the instruction again, as per the last order.
We list it next week again.
Lordship.
List it again on (12th 9/2024). On which date it is expected that the learned additional AG shall place the instructions as earlier ordered by this court. Okay, listed accordingly.
For orders from the supplementary cost list, item numbers 30 and 31.
Yes.
Yeah, please, Lordship. On the last occasion, Lordship has given me some assignment to wonder on the implementation of the 6 tribes. Now, in this connection.
No, that actually, that view was given, that opinion was expressed in order to assist you, in order to assist the petitioner.
Now,
because the order passed by the government, this court has read, it's a little vague. It only says that the reservation which was earlier shared by 6 will be shared among 7.
Yes. Now, Lordship, the entire writ petition is for non-implementation of that court order only.
Yes.
think it is okay, Lord.
Yes.
The entire writ petition is for non-implementation of the government order, that is notification dated 23rd March 2022. Government has issued an order that has not been complied with and implemented with. Agreed by that, the petitioner has approached this honorable court seeking a direction from this court to issue a direction to the government to implement the government order. It's not that the petitioners are challenging the government order. Rather, it is non-implementation of the government order that writ petition was filed. Now, if any direction is issued by this honorable court in the writ petition, it will be a direction to the government to enforce and implement the notification of 23rd March 2022.
That order is already there.
That is why, Lordship, but it is not implemented. Now, if it is to be implemented, who is going to implement this order? You will be the relevant and necessary party, that is the government of Nagaland and the Nagaland Public Service Commission. These are the two organs.
If I'm not mistaken, I remember that this court has actually issued a direction to implement that notification.
Correct.
So the matter
Lordship's
stops
memory
there.
is perfectly correct. It is intact. Yes. Yes.
So if that notification is to be implemented, definitely there will be dislocation in the reservation policy of the 6 tribes, now including Tikir 7. There will be dislocation. That is why this court was of the view that if there will be dislocation in a sense that the reservation, the quota of the other tribes will be slashed. So if that is to be slashed, then in that case, the other tribes also has to be made a party. So with that view,
yes,
this court has actually asked you to implement, to implement
correct
the other tribes. See,
Lordship.
So what is wrong there, Mr. Jamir?
That first part, Lordships, on the same day where the order is sought to be reviewed. There are 3 parts, as I was mentioning the other day. First part and second part, we are accepting that. And in the second part, Lordship has directed the government, my learned friend, to file a comprehensive affidavit.
Yes.
In what manner it is to be implemented.
Okay.
That is okay. But that has also not been done yet. Now, Lordship, advertisements are being issued one after another. Now, notification was issued in 2022. So far, and notification is very clear that it will be distributed among 7 tribes. So far, nobody has been agreed by that order except the present petitioner.
Yes, Mr. Leonard Additional AG, you have issued a notification. You don't want to streamline that notification. What is it?
Your Lordship, in the next item.
No, I'm actually coming to this first item.
Yes.
You have issued a notification. See.
Yes.
And you actually say that the earlier quota of 25% for the Eastern Nagaland tribes of Eastern 6 tribes will now be shared by the 7 tribes.
Yes, Your Lordship.
So how do we get over this issue? You have to streamline this notification. You cannot just come up with a notification and then you can just stay quiet.
It is in the process, Your Lordship. But now the matter at hand is review. It's a matter we have to confirm.
You don't take shelter under the review.
No.
I am asking, I am putting a question to
Yeah,
you.
Your Lordship.
Why you are issuing a notification without streamlining that notification?
Your Lordship, it is under process.
Under process, how long?
No, because it is not an easy matter. Because it is
You have taken a, Mr. MT, please don't give all those excuses. You have taken a decision.
Yes, Your
A
Lordship.
decision is taken
Yes.
only after formulating the policies. You know that. You have formulated the policy to let 7 tribes share the reservation, which was shared by 6 tribes.
Yes.
Yes, you have formulated a policy. Now you are saying you cannot take the excuse that it is not easy. Because the notification has to be issued only after studying the policy of the government.
Lordship. Now it has to transform into action. So we may require for some time. But your lordship, that is a merit of the case. But where the application, the petition line before it attend today's of review.
This court, see, you are not supposed to ask the court which petition I should involve in, which petition I should not. I am asking, I am putting up a question and which is relevant to the review. The question which I am putting up to you is relevant to the issue. That is why I'm putting up. Why you are taking up, or why you are coming up with a notification without streamlining? Because notification, in order to come up with a notification, you first have to properly formulate the policy.
Lordship.
And only on the basis of the policy formulated, you have to come up with a notification. You are not doing that. That is why actually the petition is coming.
Yes.
Now, Lordship, one situation. In this petition, if the petitioners are directed to participate, come and participate in the proceeding. So it amounts to also saying that for enforcement and implementation of any government order, definitely one party or the other, some people will be affected by any government order.
Mr. City,
Lordship.
what this court is concerned is that the government has issued a notification
Lordship.
where 25% of the reservation is not to be shared by 6 but by 7.
Lordship.
So if that is to be implemented,
Yes.
if actually that 25% has to be shared by 7 tribes,
Yes.
obviously a small portion of the reservation of every tribe has to be slashed.
Correct.
That is what is disturbing the mind of this court.
Yes. Now, Lordship, my problem is also, I'm just sharing, Lordship. Any government order, I'm bringing a theory so as to have more clarity of concept. Any government order issued, one way or the other, some parties may be affected. If any party is affected, they will come before this honorable court that, look, my right is going to be affected. That is there.
You are
now-
only inviting multiplicity of litigation.
No, Lordship, I'm trying to make it more simple. Now, whether for enforcement and implementation of any government order, when the party comes before the court, whether it will be appropriate for this honorable court to say that, no, those parties are going to be affected, so they should be heard before implementation of the court order. Who knows? The parties, 6 tribes, will be more happier in the event of passing any order by this court, saying that, yes, this is a very good policy, reasonable policy.
See,
we will accept this.
in our state.
So far.
In our state, you know that this reservation is very dear to those persons, to those community who are enjoying this. So if you make any attempt to slash even a part of that reservation, there will be hue and cry.
That is why government
That is why-
government order is very clear. Nobody has come forward that, no, it is going to be affect us.
Nobody has come forward, but this court is of the view that if actually like the government notification is to be implemented, it will cause prejudice to all the tribes.
That is why, Lordship.
That is why I'm saying, let the
submitting.
tribes come.
That is why
And
I'm
let them
submitting,
also
Lordship.
express what their rights before this court. Now you are saying that let this court first pass an order, and if any of the parties agree, let them come. Are you not inviting multiplicity of litigation?
No, that's why, Lordship, nobody has come forward so far.
You
So
want to
whether-
invite them, that is why. You
whether-
want to invite them.
Whether this honorable court should invite the parties that they have no grievance so far. When they have no grievance,
Mr.
why we should
Let us-
visualize
let
that?
us- Let us not take this issue in a very narrow sense. Let us not take this issue in a very narrow sense, because actually now 25% reservation, which was earlier given to 6 tribes,
Yes.
will now be shared by 7.
Yes.
So in order to give that reservation to the seventh tribe,
Yes,
you will have to make some adjustment with the reservation which was earlier given to 6 tribes.
that order is already there on 23rd March 2022.
Okay, let this, on the review, let this court apply its mind and pass over.
Lordship, second point, if Lordship is not satisfied with that, second point, on the earlier occasion, this honorable court, rightly or wrongly, the same objection which the opinion is being taken now has been raised by my learned friend. By the additional advocate general, that point was raised. I responded to that saying that no, rather the Kir is beneficiary of this order. They don't have any grievance. This honorable court has accepted that and then arrived to a conclusion that the Kir tribe is not a necessary party in the case. Now there is one order and subsequent order where review is being sought for, that is on 8 November 2023. This honorable court passed an order that 6 tribes should be heard. So now there are 2 orders, 2 different orders. One order says that they are not necessary party. One order says that they are necessary party. Petitioner has got 2 options, either to file a writ appeal in view of 2 conflicting orders of this honorable court on the
Yes.
same issue,
Why don't you take recourse to that?
or to file a review to resolve the issue. So we thought it more appropriate that it will be more appropriate to file a review to
Mr.
resolve the issue.
CT,
That was the,
let me just ask you a specific question. What is your case? What is
My-
your case in the?
my
in the
case
writ
is
petition?
non-implementation of the government notification.
And why it has to be implemented?
Basing on the government order is issued to implement,
Huh?
but that is not implemented.
Implement
So
what?
petitioner
Implement what? Let us.
to implement the order, that is to share 25% quota among the 7 tribes.
Previously
instead
it
of
was
6
shared,
tribes.
previously it was shared amongst how many
6,
tribes?
it was 6 tribes.
So now 7.
Yes,
So that is what I'm saying. If you are to slash the reservation of each tribe, will they not be adversely affected? That is why this court says that, okay, also implement them. Let us hear from all the
whether
parties.
they will be affected or not, we don't know, because the order has not been passed yet. This honorable court has not passed the order yet. And that is not implemented.
Lordship, I will be allowed to submit a few points. Your Lordship, the present application is a review. Order for this one, roll 1 CVC. This review scope is very limited. It's not a bill. So it has, the applicant has to come within the view of the.
Mr.
roll 1.
MT.
Yes.
Have you filed any objection?
No, review, it is a review.
That's why I'm asking you, have you filed any objection
No,
to
no,
the
no.
review?
No, in the review, without objection, again, submit more.
This court will not allow you without
No,
your
no,
affidavit.
your Lordship. And then the.
You have no right to
No, no,
submit
your
without
Lordship,
affidavit.
I will be allowed to submit one point. Whether the submission of the applicant is amount.
You
accounted
put,
within
you
the
put in
view.
affidavit. This court will hear you. You put in affidavit. And you cannot say that even without filing affidavit, I have a right to hear you.
Whether the view of
What
the.
kind of submission is
Your-
that from
your
an
Lordship,
additional
as
AG?
per the CBC, whether the view of the court can become under the error of the court, error of the record.
You
No.
if you want to submit on this review, you file a short affidavit saying whether it is necessary to actually implement those person or it is not necessary. You file a short objection in the form of an affidavit.
So.
But
without
you
a-
cannot actually make
No,
every
no.
submission under the sun.
No,
You have
your
no, you
Lordship,
don't have the right.
my submission on the order for this one, roll 1, CVC. So review, it doesn't mean that I can submit. I
Mr.
can submit.
MT, are you filing affidavit or not?
So if they permit, I'm ready to file affidavit, but I'm basing on the order for this one, roll 1.
This court is well conversant with that provision.
Yes.
I am asking you whether you want to file affidavit or not.
Yeah, I can file.
Don't make any submission under the sun as you wish. There is a provision, you follow that.
Yes.
And you are standing here in the capacity of an additional AG.
Yes.
How can you make that submission?
I know. So I'm just submitting before your Lordship. Whether the view expressed to
So
the
much
court.
time has passed. So much time has passed. You did not file even a single line petition.
No.
And then this morning you are saying that you have a right to be heard.
Your Lordship, review revision appeal without the affidavit, I can.
If you have objection or not, it has to be put, at least put it in the form of an affidavit. Review, revision, everything, those court knows. But if you want to make any objection, or if you want to substantiate, or if you want to support, at least put an affidavit, at least 2-3 line affidavit. And then making a submission that you can make a submission even without the affidavit. As if you're the court.
No.
Yes, we allow you 1 week's time to file affidavit. Mr. M. Timsong, the learned additional AG is allowed 1 week's time to file affidavit on the review petition filed by the petitioner, listed accordingly.
Your Lordship.
Next time, don't come with excuse.
Your Lordship.
On the last occasion also, my learned friend was directed to file a comprehensive affidavit, how to
No.
implement the policy
Your
also.
Lordship, that is in the next item, WBC 240.
So since there is an order of the court, comply it. Right? There is an order passed by this court asking you to file a comprehensive affidavit, file it.
I'm waiting for the instruction, Your Lordship.
You have actually taken a policy and then you are putting now everything on the court. What kind of policy the government is making without first formulating the policy? If a policy is formulated, it has to state as to how it has to be implemented before the notification is out. You are putting the bullock, you are putting the cart before the bullock and inviting problems for everybody. Okay.
For hearing,
Your Lordship, my sincere apologies. Earlier from the supplementary post list item 27, there's an interim period, Your Lordship.
Okay, ma'am. The interim order passed earlier shall continue till the next return of the deeds.
Obliged, Your Lordship.
Yes.
for hearing, item number 7.
May it please your lordship.
Mr. P.B. Paul.
Yes, your lordship.
If not for the road, I would have asked you to personally, physically appear. Hearing matters, unless you are a long distance lawyer, it'll always be good to be physically present so that we can hear you.
Then after 2 weeks, the matter may be fixed, your lordship.
Well, what is this matter, Mr. Tongpok?
Your lordship, it pertains to land issue in Purana Bazar B.
Oh,
Yes, that same.
That issue, whether the
Yes.
village council has the authority to
Yes,
issue. Okay.
yes.
That I think it'll be very kind of you if you can kindly come and physically appear. Okay, we understand that the condition of the road is bad.
Yes, your lordship.
Can't hear you.
Yes, the connection is freaking up.
Am I audible, your lordship?
You are not audible.
Yes, I'm not audible, your lordship.
I'm now audible, yes.
Yes, your lordship. Then, your lordship, after 2 weeks, if the weather is clear, then and road is being, after 2 weeks, your lordship.
Yes.
Your lordship.
Yes, because this court desires that it will be very kind of you if you can come and appear in person.
Yes, your lordship. Yes, your lordship. Welcome. Welcome. We will come, your lordship.
Okay, Mr. Angan.
Lordship.
When can we have it? When can we have it, Mr. Tom?
Your lordship, I have no objection to the learned senior counsel's request. 2 weeks also, because the condition of the road very unpredictable.
Yes. List it again after 2 weeks.
Your lordship, the interim may continue.
Yes, Your Lordship. The interim order passed earlier shall continue till the next returnable date. Okay. After 2 weeks.
Much obliged, your lordship.
All hearing item numbers 8 to 12.
What is this matter?
Well, please, your lordship. Your lordship, this matter is about compensation, my lord. Land compensation. Now, my lord, here, an IA has been filed by the NHIDCL, the respondent number 6,
Yeah.
for withdrawing their affidavit, additional affidavit that they filed, your lordship.
Who is respondent 6?
The NHIDCL.
Yes, Mr. Moa. Why you want to file your affidavit so beautifully drafted?
Lordship,
Your lordship.
I've stated in my IA, Lordship, that typographically occasion, Lordship.
So instead of withdrawing, file one application.
They have filed an application to withdraw. But your lordship, I have an objection to that because they are, in my respectful submission, your lordship, not the council, but the NHIDCL is trying to mislead this honorable court, and I can prove it by way of documents, my lord.
Well, what is your this affidavit?
Lordship, if I may be allowed to make a submission pertaining to the IA, Lordship. We have engaged 3 different contractors on 3 different occasions for execution of the project, Lordship. The reasons being, one was foreclosed and the other terminated, and the third one is on the field now, Lordship. Now we have also executed contract agreement with all the 3 contractors, Lordship. Now, as per the first and the latest, the third contract agreement, in a stretch of road, it is around 4 kilometers, Lordship. There is no provision for expansion of the road, whereas it is only for improvement and strengthening of the road, Lordship. Now, the prayer in this writ petition is claiming for compensation as well as for widening of the stretch of road. Our prayer before this honorable court is that, Lordship, since as well the DPR as well as the contract agreement, there's no scope, there's no provision for expansion of the road, but it is only to strengthen on the existing road. So the question of compensation will not arise. That is our
No,
contention.
Mr. Moa,
Lordship.
why withdrawal? Well, if there is any inadvertent, inadvertent statements or inadvertent error, or you
Yes,
can
Lordship.
always make a small application for correcting the error.
Lordship. If
I think that Mr. Joshua will not have objection.
That is impermissible, your lordship, because by way of documents, my lord, they filed an affidavit in opposition against my writ petition, my lord. And in that, they quoted a 6035, a particular number 6035. And they say that it is within the stretch of the road where my clients are seeking compensation. Then, my lord, I question that because there is no clarity that this particular stretch of the road falls under 6035 and that there is no scope for widening and strengthening. So when I question that, my lord, after I question that, this honorable court passed the order 13/11/2023, and in this order, this honorable court directed the NHIDCL to file additional affidavit to clarify whether that particular stretch, which they have mentioned in their affidavit, actually falls within the category where there is no strengthening and widening. Then, my lord, when they file the additional affidavit, the lordship will see that in the additional affidavit, not the entire stretch of the road where the petitioners are claiming compensation, my lord. But there is a particular chainage, it is strengthening and widening. So after seeing their affidavit where they have annexed the contract agreement, my lord, it is clearly there that there is not all the petitioners will benefit, my lord. But particular stretch of the road, there is strengthening and widening. So after I filed an additional, I filed a affidavit in reply to their additional affidavit. My lord, they filed this IA claiming that it is a typographical error. This writ petition was filed in the first part of 2021, my lord. Then, my lord, right after this writ petition was filed, that contract agreement was executed in the month of September, my lord, 2021, my lord. Now, and then in that contract agreement, a particular stretch of road within the area where my client's lands are, my lord, there is widening and strengthening. So now, after 3 years, they say that it is a typographical error. My lord, the law is settled, my lord is fully aware. As far as the settled law is concerned, what can be termed as typographical error? It is not a typographical error, my lord, only because they want to deny the benefits of compensation to my clients. Now they want to amend their contract agreement, my lord. An amendment does not amount to, lordship, it does not amount to a typographical error, my lord. So, lordship, if my lord is willing to take up this matter now, I will show by way of documents on why the NHIDCL is trying to mislead this honorable court by.
What is the last
Yes, your lordship.
application you have filed?
Lordship, the latest application is pertaining to just to withdraw and file the third contract agreement.
Have you filed an objection to that?
Yes, your lordship. It is not a typographical error, my lord, as per the settled law, my lord.
And lordship, we highly appreciate. Our intention is not to amend the contract agreement, but to
Your
produce.
intention is not to have?
Amend the contract agreement, but to produce the latest contract agreement that shows that in that stretch of road, there is no geometric improvement, meaning otherwise, no widening is there, lordship. So I have also.
Have you stated that in your application?
Yes, lordship, yes, lordship.
Let us.
I've stated, lordship. If lordship, can you allow me to?
Right.
What is that application?
It is registered as I-74 of 2024, lordship.
Yeah.
If your lordship got it, lordship,
There's an additional affidavit for and on behalf of respondent number 6.
Yes, that is an additional affidavit, lordship. And pursuant to that, lordship, I've also filed one IA, lordship, which is registered as IA number 74 of 24. Lordship. IA number 74.
This is IA 74, this is WPC 194. IA, this one.
If I may be allowed to read paragraph 2, lordship.
This application praying for relief of this honorable court to withdraw.
Lordship, yes, lordship. The additional affidavit which was filed on 4th March 24. And to rectify the uninterpreted typographical error.
This is only for rectification, not for amendment.
Lordship.
So that is why, your lordship, what can be termed as typographical error? I will satisfy this honorable court, my lord.
Lordship, in order to bring the clear picture, if I may be allowed to read paragraph number 2, lordship, page 10. 10. May I read it, lordship?
Yes.
That in compliance to this honorable court's direction, the present applicant filed an additional affidavit on 4th March 24, placing on record a contract agreement executed on 18/11/2021 between the NHIDCL represented by MD NHIDCL and the EPC contractor, that is MD Enterprise. Annexure 1 attached to the Schedule 1 of the contract agreement provides description of site of the entire project from existing kilometer 74 plus 640 to kilometer 98 plus 065. Design kilometer is 63 plus 800 to 86 plus 835. With regard to improvement proposal in terms of the said provision of the contract agreement dated so and so, no geometric improvement is required for the stretch of road from SSB Nala, that is design change.
What is the meaning of geometric improvement?
Geometric improvement contains the extension of road, lordship. geometric improvement is some improvement which is made on the existing road, Lordship. Whereas our contention is that it is just strengthened by the top two layers, that is BCA by 50 mm and the second topmost layer by 40 mm, Lordship. Now coming to this, Lordship, the SSP NLR changed 82 plus 465 to design changed 86 plus 835. This is important because this is the stretch of road where all the petitioners are the landowners in this stretch of road, Lordship. And this is the subject matter of this case, Lordship. However, for design changes kilometers so and so, page 189 of the contract agreement, a typographical error had occasion whereby for improvement proposal, it is indicated as whitening and strengthening required for subgrade layer. Whereas as per the detailed project report submitted by MS Rights, it is specifically mentioned in paragraph 4.2.7 that no geometric improvement is required for the aforesaid stretch of road.
So what is the typographical error?
We have stated that there is strengthening and whitening is there, Lordship. So the word whitening, Lordship.
Which?
I've just read, Lordship, this paragraph.
Which paragraph?
The same paragraph that I'm reading, Lordship. And
yes, para 2.
Para 2, Lordship. Yes,
Which is that typographical error? In para 2?
Page 11. If Lordship, we kindly come to the line that starts with subgrade, a typographical error, Lordship. It will be a 11th line of page 11, Lordship. The typographical error had occasion whereby for improvement proposal, it is indicated as whitening and strengthening required for subgrade layer. Whereas as per the detailed project report submitted by MS Rights, it is specifically mentioned in paragraph 4.2.7 that no geometric improvement is required for the straight road.
So this is the only.
Yes, Lordship. Only the
Mr.
word
Joshua, I
whitening,
think
And
why are
your
you so
lordship-
much against this?
No, your lordship. It's a very clever use of language rectification. It
Okay,
will
let
amount to
them
amendment, your lordship.
let them actually let them actually correct the error and then you file
No,
an
your
objection.
lordship.
You
Your
file an
lordship.
objection.
No, your lordship,
Why
my
should we
petition,
stop them?
my petition will become infructuous, your lordship. The whole issue goes.
If they actually file an application
Your lordship,
correcting the
whether,
typographical error, whether your petition becomes infructuous.
definitely, your lordship. And my lord, whether at a belated stage, your lordship, can this be termed as
You have
typographical
every
error?
opportunity to raise objection to the
Your lordship, that's
application
why
filed by them.
no, your lordship. That is why I'm raising my objection. How can this be termed as typographical error? I have filed my writ petition in the month of September 2022. They have entered into this contract agreement in the month of November 2022, your lordship. Now, after many years, just because I filed affidavit in reply, in objection to their claim, can they now turn around and say that it's a typographical error after 2-3 years, your lordship? It is not a typographical error, your lordship. If it is accepted as a typographical error, my lord, my entire writ petition goes.
See, even if we allow him that opportunity, you have every opportunity to
No, my
rebut.
lord.
Who is
That-
stopping you?
That is why, your lordship, I have rebutted by filing an objection
So
to
this
this.
application,
Yes, your lordship, I have filed an objection to this.
no, if we allow the typographical error to be rectified, you can always file an objection to that.
I have filed, your lordship. It
We
cannot
have not
be.
allowed. We have not allowed.
So it cannot be allowed, your lordship. Once it is allowed, my writ petition goes, my lord. The entire writ petition goes, your lordship. No, my lord. If I
Yes,
may.
Mr.
Yes, your
Whether the
lordship.
entire petition goes.
Yes.
The petitioners in the main writ petition, they have not even made even a single whisper as to what kind of properties were damaged, how the course of action arose, lordship. In fact, there is no locus to approach this honorable court, lordship. Because there's no extension of road. So if there's no extension of no road, lordship, no properties will be damaged, lordship. Only if the properties are damaged, they can approach the appropriate authority or appropriate forum, lordship. In fact, in the first place itself, there is no locus to approach this honorable court, lordship.
That's an unfortunate submission, your lordship. That's very unfortunate, your lordship. Because only when there is extension, then your lordship, assessment will be made.
Lordship, may I complete the paragraph, Lordship?
Hmm.
Page 11, Lordship, subpara. Be that as it may, the petitioners in the present read petition belong to Mon district, which comes under package 4 of the project for construction of balanced work of construction of 2-lane road with hard shoulders of Merangong Kamlu Mon Road on EPC basis from so and so in the state of Nagaland under SERDP phase 1. For construction of package 4, the authority has initially awarded LOA to so and so on 28 March 2018, and the contract agreement was executed between the parties on 11/4/2018. However, after completing for 24.64% of the project, the contract was foreclosed on 30 August 2021. Subsequently, MD Enterprise was appointed for construction of the balance work white LOA dated 19/12/2021. However, the same was also terminated by order dated 14 March 2023 after completing 9.57%. Thereafter, by LOA dated 9/6/2023, MSSS Infrazone Private Limited was awarded for construction of the balance work. It is pertinent to mention that 3 separate contract agreements were executed between the parties for the aforesaid facts and circumstances, and while executing the said contract agreement, it is specifically mentioned that no geometric improvement is required for the aforesaid stretch of road except in contract agreement dated 18/11/2021. That is the the contract agreement which has occasioned the error, whereby it is inadvertently indicated that for improvement proposal for design changes so widening and strengthening is required for subgrade layer. It is also respectfully submitted that the aforesaid additional affidavit was filed without ascertaining the correct description, more particularly at page 189 of the contract agreement, due to oversight, and hence amply praised for leave of this honorable court to allow the applicant to withdraw the additional affidavit and thereafter graciously be pleased to have permit the applicant to file a fresh affidavit producing on record the latest contract agreement executed on 28/8/2023 between the NHIDCL and SS Infrazone Private Limited, MS Shyam Construction joint venture in the interest of justice. This is my submission, Lord.
Mr. Joshua, fresh application will be on the basis of the contract agreement. What
My
is
lord,
wrong there?
My lord, please allow me to satisfy this own court. I'm not representing my own cause. It is the cause of the petitioners, my lord. I will take your lordship to.
Oh, you are representing them.
That is why, your lordship, I may be allowed to show the first affidavit filed by the NHIDCL to my writ petition, your lordship.
Ah.
I'll just show your lordship brief points, your
No,
lordship.
even if it is inadvertently filed, you don't want to make them, allow them to make any corrections.
Your
Is that your
lordship,
case?
your lordship,
If that is your case, we'll dismiss your.
no, your lordship. I sincerely pray before this honorable court, allow me to show your lordship why this is misleading. It's misleading, your lordship, and I can satisfy this honorable court.
Hmm.
Please allow me to show your lordship.
Only on the IA. Only on the IA, what is your objection? Let us see.
No, your lordship. To show that this is a misleading IA, I have to show your lordship on the first
You
affidavit.
have filed
filed
your
by-
objection to this, no? You have filed your objection to this.
My lord, yes,
Let
your
us,
lordship.
let us first see your
Your
objection.
lordship, your lordship. No, my lord, this objection is filed.
Where is your objection? Where is your?
37/2024, I have filed an affidavit in opposition for and on behalf of respondent number 7 to 48 in the above mentioned application. Your lordship,
Hmm.
has your lordship?
Hmm.
Okay. May I be allowed to read, my lord?
Yes.
It's a brief affidavit. I have received a copy of IA civil number 74/2024 filed by the respondent number 6 seeking withdrawal of the additional affidavit filed on 4/3/2023 to rectify an inadvertent typographical error and to file a fresh affidavit. Having perused the IA, I beg to file this affidavit in opposition so and so, your lordship. Then paragraph 2, your lordship, that before adverting to the statement made in the IA seeking withdrawal of the additional affidavit to correct the typographical error and to file fresh affidavit, It must be appreciated by this Honorable Court that the law is settled in this aspect. The excuse of typographical error cannot emanate from negligence or a conscious action. The term typographical error is defined as a mistake made in a printed typed material during a printing or typing process, which can result due to mechanical failure or slips of the hand or finger, which usually excludes errors of ignorance. Any amendment sought cannot be at the cost of causing prejudice to the other side, which cannot be adequately compensated by money. To claim a typographical error after 2.5 years of the contract agreement is unsustainable in the eye of law. Save and accept, Your Lordship. Then paragraph 4. The answering deponent do not object to the statement made at paragraph 1 of the IA, as the same is extract of the order of this Honorable Court dated 13/11/2023. It is, however, to be noted that on the submission of the counsel for the petitioners, that after the initiation of the works, that a decision was taken not to widen the stretch of the road in Mon Town portion SSB Nala design chainage 82 plus 465 to Techanala design chainage 86 plus 635 Sever Point. In this regard, the counsel for the petitioner sought clear instruction to explain the stand of the respondent NHIDCL. The petitioner's counsel alleged that the decision is not to widen and strengthen the portion of the land was taken behind the back of the petitioners, and the same is beyond the DPR. Pursuant to the strong allegation made by the counsel for the petitioners in the order dated 13/11/2023, that the respondent NHIDCL filed the additional affidavit on 4/3/2024, wherein the contract agreement dated 18/11/2021 was annexed as Annexure A to the additional affidavit. At page 197, the serial number 329 of the table column specifically shows that a widening and strengthening is available for the design chainage 82 plus 600 to 83 plus 300, which is 700 meters. To turn around at this belated stage is not permissible in the eye of law. Is not permissible in law, but it also shocks the conscience of any common man and devoid of simple common sense. The statements made at paragraph 2, 3, and 4 of the IA is without any merit. The additional affidavit was filed pursuant to the order dated 13/11/2023, wherein the counsel for the petitioners made a strong allegation. Be that as it may, the respondent number 6, applicant NHIDCL, had sufficient time between 13/11/2023 to 4/3/2024 to either correct the so-called typographical error or even temper or distort or manufacture or doctor the document/contract agreement, because the sole intention is to deny the petitioners from receiving any form of compensation. It is too late to turn around at this stage to claim typographical error on an outrageous excuse. If at this belated stage, the respondent NHIDCL is allowed to withdraw the additional affidavit filed on 4/3/2024 by allowing the present IA, it would greatly prejudice the petitioners and cause irreparable damage to the petitioners, which cannot be compensated with money. So, Your Lordship, the same chainage in the first affidavit that they filed also, they did not annex the contract agreement, my lord, but they have quoted the same chainage without annexing the contract agreement, stating that there is no geometrical improvement, Your Lordship, strengthening and widening. The first affidavit of against the writ petition also, they claim that there is no strengthening and widening, Your
The
Lordship.
prayer for withdrawal and to file the correct copy of the affidavit on the basis of some agreement. If that prayer is met, whether it will be proper for this court to stop the NHIDCL from filing a
My
correct
lord,
affidavit.
my lord, here, if my lord may kindly appreciate this point. Here, if they are allowed to withdraw by filing the fresh affidavit, Your
Okay,
Lordship,
we
they will
will
bring a
not allow
new,
you, but you file your corrected affidavit.
they will bring a fresh contract, Your
Yeah,
Lordship.
that is why we are not allowing them to withdraw, but we are
Okay,
allowing
well.
them to file an application so that you can get every opportunity to file
Your
objection to
Lordship,
that.
Your
We
Lordship.
will keep this additional affidavit on record.
This IA will also be kept alive, my lord.
Yes, yes.
Yes, Your Lordship.
Yes,
In
we
that case,
keep
Your
this
Lordship.
idea alive.
My lord,
But let us also see at least what they are actually asking from this court.
my lord,
And whether actually like the prayer which they are seeking is justified.
Your Lordship,
You can also have every opportunity to object to that.
my lord, my lord. In that case, my lord.
Third, Mr. You are the applicant,
Lordship, I'm the applicant.
Mr. Jamir, the learned counsel for the applicant. And Mr. Joshua Shakti, the learned counsel for the opposite party petitioner.
Yes, your lordships.
And Mr. L.T. Sankam, the learned additional AG for the state respondents.
My lord, I'm for respondent number 2.
Okay, and Mr. So-and-so appears for the respondent number 2. This application has been filed by which respondent?
Respondent number 6, my lord.
6. The present application has been filed by the applicant / respondent number 6. Praying for leave of this honorable court to withdraw the additional affidavit filed on 4/3/2024. To rectify an inadvertent typographical error and thereafter to file fresh affidavit. After hearing the learned counsel for the petitioners, for the parties, this court is of the view that the petitioner, the applicant, respondent number 6, no. After hearing the parties, no, not that, cancel it. The inadvertent typographical error has been set out in paragraph 2,
Lordship,
of the application, which reads as follows. Up to this aforesaid stretch of the road. Okay. Mr. Joshua Shaki, the learned counsel for the opposite party petitioner, submits that if the applicant is allowed to withdraw the additional affidavit, and to file a fresh affidavit, it will seriously cause prejudice to the opposite party / petitioner. After hearing the learned counsel for the parties, this court is not inclined to allow the applicant to withdraw the additional affidavit filed on 4/3/2024 on behalf of the respondent number 6. Stop. The applicant opposite party number 6 is however allowed to file an affidavit bringing on record, is however allowed to file an application bringing on record the typographical error supported by an affidavit. Okay? Let us- And in which event all opportunities shall be given to the opposite party petitioner to raise objection to the application filed by the applicant, bringing the typical typographical error on record. Listed on
2 weeks.
listed after
2 weeks.
2 weeks. Okay.
Much obliged, Your Lordship.
For hearing, item number 16.
May it please, my lord. Lordship, I have filed an affidavit last evening, Lordship. I was actually permitted by this honorable court by the. by the
Mr.
previous
Senti,
order,
you are
Lordship.
representing?
The NHI this year, Lordship.
Okay.
Respondents 1, 2, and 3. The Deputy Commissioner has sent the NHI this year verification report, Lordship. We are objecting to that, Lordship. Under that assessment report, we are the damage compensation has been arrived at 1 crore 16 lakhs, Lordship. Now, Lordship, we have strong objection to it because the cause of the damage. Lordship,
That verification was undertaken by the Deputy Commissioner Kohima.
Yes, one of our engineers.
verifications.
Yes, one of our engineers was also present, Lordship. That fact is not disputed. However, Lordship, he was shown around the property, Lordship, and beyond that, Lordship, his opinion was not taken into confidence at any stage, Lordship. And the Forest Department also. And Lordship, the case is that he has already been compensated earlier, Lordship, because the right of way is for 45 meters and road is constructed on 24 meters only. And the ROW has also not been, where it begins and where it ends, that also has not been stated, Lordship, neither by the state, Lordship, to be fair. And
What is the width of the road? What is supposed to be the width of the road?
24 meters, Lordship.
24 meters.
Yes, and the ROW is for 45 meters.
45, and the construction has been undertaken only within that 24 meters.
Yes, Lordship. Because Lordship
And your compensation is for 45 meters.
No, Lordship, he is saying that while executing the contract work, his property has been damaged. The land compensation, the other compensation we have already paid, Lordship. And how much amount he has received, under what head he has received, that also is not present in the writ petition, Lordship. Despite him admitting clearly in this annexure 1 to the writ petition that compensation has already been paid to him.
Mr. MT, whether it will be necessary for the state to also file affidavit?
Now, Your Lordship, we have filed only this morning, we have filed a joint verification report.
Only this morning?
Yeah, only this morning.
In the form of an affidavit?
Your Lordship.
Mr. Senti, when is your affidavit dated?
Yesterday, Lordship, 4/9, I don't know whether it is on record, Lordship.
4-9.
Yes, around 3:30 I was able to find it. Lordship.
Same thing?
This morning only.
This morning also.
If it can be brought on record and we can take up the matter next week, Lordship, as per my Lord's convenience.
If you are raising a strong objection, I think he has to file a reply to that.
Just this morning only, I received the copy filed by them.
So I think you will have to rebut the objection.
Lordship, and even the state respondents, they have just furnished to me.
Okay, okay.
So.
Mr. Okay, Mr. You heard Mr. Kikringoli, the learned counsel for the petitioner, Mr. Im Tim Sung, the learned additional AG for the state respondents, and Mr. Sintianger.
For respondents 1, 2, and 3.
The learned counsel for the respondent number 1, 2, and 3. It is submitted by the learned counsel for the respondent number 1, 2, and 3, as well as by the learned additional AG, that the affidavit has been submitted on behalf of the respective parties. However, the same is not on record. Registry to trace the same and place it on record. List it after 2 weeks.
Lordship.
In the meantime, the
Reject the
learned counsel for the petitioner shall also file reply, affidavit in reply to the affidavit in opposition filed by the respondents, if so advised.
My lord, in view of that matter, if it can be listed in admission, Lordship, not in hearing, because Lordship, pleadings are not completed at this stage, Lordship.
Lordship, in this case, why it has been listed under hearing on 14th May 2024. Pleadings are completed and matters are posted for hearing. Thereafter only they have come to pray for the filing additional affidavit. And even the state respondents, they were praying time to file that verification report, time and again.
So you tell this court which will be appropriate.
Lordship, it will come for.
Whether it should come up for admission or hearing.
Lordship, it may come under order, Lordship. Order.
Okay, listed in the order column. Okay.
Much obliged, Lord.
Obliged.
May I please, your lordship?
Yes, please.
My sincere apologies. Earlier in item 27, which is in motion, there is an interim. Earlier it was passed that regular
Motion?
interim. Yes, your lordship.
Motion?
Yes, your lordship. There's an interim prayer.
Interim prayer.
Yes. Earlier, I stated that, but it was passed as regular interim. That's why I wanted to rectify, your lordship.
No, but the government has already appointed the respondents. So where is the question of actually like kicking out that respondent?
Lordship, because the petitioner has submitted application as well as representation, and there was an agreement, but still the government.
Okay, in a motion, the appointment of the private respondent shall be subject to the outcome of the writ petition. Okay.
Obliged, your lordship.
Yes. Oh, this, where is this? 94? Okay.
Part 1 0, part 1 0,